Okay, let's get this session going. Good afternoon, thank you for coming. Great to see you. I'm sure the SGA will be very pleased that you're very intrigued on this. This actually is the MGAA's third session on GDPR, and I'm very actually grateful to our friends at EC3. And the reason that they're here today is because we are going through exactly the same problem. We obviously capture a lot of data, we hold it, and we play with it, and we use it for our members. So I said to Helena, look, can you come and see us, tell me what we should be doing, tell me what we shouldn't be doing, and can I ask you, like guys and girls, this? No, I can't do that because that's marketed, and they'll probably come on to that as well. So we're pleased that we've got Sarah Ager here, who's a partner, and Helena, legal director. And Helena, actually, as I say, has actually taken me through this possession. And I call it a possession because I own it. It's a pain. We will be podcasting, but only the presentation. What will happen is when we go into a discussion, that won't be podcast. So please feel free to actually speak and throw things in, especially you, young man, because I know what you're like. But please, I'm going to hand you over now to Helena, who will tell you all about it on a more practical level than what we've done before, which is more high level. But please be here. It's your session. Do feel free to raise your hand and ask questions. Would you like them during, after, end?
Whenever.
Whenever.
So, yeah, we're welcome questions, comments, whenever.
Yeah, perfect. So I'll leave it to our friends. Thank you.
So I'm just going to quickly, for those of you, hi everyone, don't be worried, this is going to be much more interactive than hopefully any of the other sessions you've had. Data is dry, so we start with that as the precursor. But actually a requirement of all our business, and actually we hope isn't as complicated as some of you might be finding it. So today we're really going to steer around a practical view around the GDPR. We've given you a document which hopefully you find useful, you can take away, that sets out all the technicalities of the regulation which seem to become law. Please use that as cross-reference. If you need it in soft copy so you can distribute it amongst your business, then you can give us a call afterwards. For those of you who don't know EC3, we've been around for about 5 years. Our senior partner is David Coop. He sits on the board of the MGAA. And for my sins, Helena and I decided that we really needed to get our practice up to speed with GDPR. So we're helping the MGA. We're also doing it for our own firm. And we also have a number of clients in the insurance sector, ranging from forensic accountants, loss adjusters, MGA businesses, large wholesale brokers and small retail brokers. In all the sectors, some hold personal data, some hold sensitive personal data. So hopefully we can give you a take and a view on how you can navigate yourself around the regulations. So, we'd like your feedback. So if we don't achieve that, then please tell us, but hopefully we will. We're happy to take questions at any point, and there will be a couple of really short interactive sessions, just to make it not so dry, where we're going to be asking you what you think, what you might be doing in the scenarios. Hopefully we might know the answer, but we're going to use your brains anyhow. With that, I'm going to pass over to Helena, if that's okay.
Thank you. Are you clicking?
I'm clicking.
Good. Okay, well, thanks for having us. Thanks for coming. As Sarah said and Peter said, I'm going to try and make this more practical and not too dry, not too legal, but I will refer to some of the legal principles because I think they're helpful in guiding you through what you do from a practical perspective. So one of the problems I found with the GDPR and what I've found when working with clients is that it was introduced for all industries that deal with personal data. And you know, like I know, that they didn't really think about the insurance industry, let alone the intermediary space, when it was first dreamt up. And so we've had to try and get our heads around how it works for us as an industry. So I'm going to be trying to look at that as well, and particularly the distribution chain and the contractual matrix and relationships we have in this industry. I am going to break it down into various pointers, and the reason I'm doing this is because I feel this is what's helped me in helping clients. So I've broken it down into what I've called 7 steps. It's not ICO approved, it's not anyone approved, it's Helena Coates' 7 steps to the GDPR. So I hope it will help you to think about it in a practical way. I appreciate some of you might be further on than others in your preparation. So I apologise in advance if I'm overlooking that, but I do think in terms of looking at your preparation, it does help to start at A and work through to Z. So we have a few learning objectives today. That's the number 4. Yeah, so these are the learning objectives. As I've said, I'm not going to go through them, but we are going to identify some easy steps. And if you haven't taken any steps at all, I'm going to identify where you can start quite easily. Some steps are easier than others, particularly when we get onto the more of the contractual relationship side of things. But we have got some industry guidance on that, which should be helpful if you haven't come across it already. So, on to just a bit of background. You've heard all of this, I'm sure, when we're talking about high level, that this is exactly what you've heard. But the difference right now is that the GDPR will be effective here as of the 25th of May. And in my calculations, that's 45 days from now, so 6.5 weeks. When I looked up on Google what you could achieve in 45 days, it said you could achieve a 6-pack and lose a stone. So GDPR seems quite easy based on that. So it imposes, as you know, new obligations on controllers, obligations on processors that weren't previously there, the rights of data subjects, so the rights of individuals, we all know that's what it's all about. And then we've had these headlines, the big fear factor, the fines, the sanctions. But in actual fact, and again, this isn't ICO approved, but my understanding is that those fines are just reserved for persistent, serious breaches, when you've got companies who are completely ignoring the rights of individuals and the protection of this data. So whilst you need to be prepared, don't be petrified. And if the ICO, if you have a breach, that's obviously the worst case scenario, and the ICO comes in, what they're going to be looking at is what you've been doing as an organisation in order to prepare. So if you are doing all the right things, if you have your records, if you have your procedures, and not just written procedures, followed procedures, then they're going to be a lot more lenient on you if you do have a breach. So I think that's to keep in mind when you see these, whatever they are, Metro or Daily Mail headlines. So, I think I'm going to pass back to Sarah now, just to talk about a bit of context. And the reason why I want to do that is because there are several principles in the GDPR, and one is the principle of accountability, and that sits behind everything else. And Sarah's much better placed to talk about awareness and governance within organisations, so she's going to cover this bit.
So I'm going to talk about accountability. I'm accountable for accountability. So really, for me, step one, and I think this is for me the most important, is the backdrop to everything else. It's actually having board awareness, board sign-off, board approval, and audit trails of decisions and policies which you can do within your organisation which support what you say you can do. So, you know, it's no different to anything else that's regulated at the moment. The principle is get your board to own it, get your board to live it, breathe it, and get the board to make sure that the business understands what they're doing. And that's really just what GDPR is asking you to do. There's no point having your IT team doing GDPR assessments on how you hold personal data if the rest of your business don't understand what that means. And by that I mean they need to be trained, they need to know why they're holding data and what kind of data they are holding. So as a board or a senior member of your organisation, you need to make it palatable and something that your business can understand and work. And we're not just talking about external parties, i.e. people you deal with, we're now also talking about your own employees' data. So this is the first time that as an organisation you have to make sure that you have the right checks and balances in respect of your own personnel and staff. Everyone's worried that they need a DPO, Data Protection Officer. The answer is not everyone needs a DPO. The regulation is all about proportionality, so in much the same way, whether or not you need a data protection officer will really depend on the volume of data you're holding, the type of data you're holding, and the complexities of your systems. So if you deal with business that holds or requires lots of sensitive personal data to be held, and you have whole reams of archive systems and systems in run-off legacy systems, then you may need a DPO. But what the regulation is really looking for is someone on your board that says, yeah, there's a data problem, that's my problem, and I'm going to be responsible. My advice to you is that your data person probably isn't your IT manager, because there are situations where there might be conflicts between that, where the data breach is as a result of something wrong in the IT systems, processing, architecture, and as such you need that independence, that check and balance. Most important thing is whatever you document, and I'll reiterate what Helena said, as far as going through this whole GDPR process, how you're assessing your data, how you're holding your data, and how you're going to do it going forward. You need to have your decisions capable of being audited. So with all these things, the ICO is going to come down on you with a huge, great big fine if you can justify how you've made that decision. If you've made that decision and it's in accordance with your own kind of risk appetite within your business, and you can justify why you've made that decision, the fine is likely to be far more reasonable. I'm not going to say that's going to avoid you having your knuckles wrapped. However, they will look at it in the light of the decisions and how you arrived at that decision. So awareness, accountability, staff appreciation and senior management ownership, for me, this is the key to this regulation.
Next slide. So that was step 1 of my 7 steps. Step 2 is as legal as it's going to get, mostly, until we get onto ToBAs and binding authorities. But for now, the reason I think it's important to consider this as one of your steps is because the 6 principles in the GDPR, which we've listed here, form the backdrop of everything you do. So every practical step you take is going to relate to one of these principles. And I'm just going to run through them quickly. The first being that your processing has to be lawful, fair and transparent. And lawful means that you have to be able to justify that one of the lawful grounds in the GDPR applies to your processing and to your specific processing. So let's take, for example, using personal data for marketing purposes. You will need a lawful ground within the GDPR to do so. Fair is a bit of a weird one. It basically means that the individual doesn't think it's unfair for you to process their data in that way. And I've seen a quote that said that it shouldn't be sneaky, creepy or dishonest. So I don't know if that helps at all. But, and then within that first principle, there's the transparency aspect. And that means you have to tell the individual what you're doing with their data, why you're doing it, and the lawful ground upon which you rely to do it. And we'll get onto that because that links in with how you tell them and your privacy notices. The second principle I always find a little bit vague, purpose limitation. You should only be using the data for the purpose for which it is collected. And again, you can use marketing as a simple example of that, but it could be to obtain a quotation on behalf of an insured or whatever it is. So that's the purpose. Data minimization. Did I say that right? Minimization. You should only collect what you need for the purpose for which you need it. So if, for example, you only really need the name and the date of birth as an individual, don't get their home address. You don't need it. It's not worth it. And actually going forward, your processes and procedures might encompass that so that everybody within your organisation knows that that's what they do and that's why they do it. Accuracy. So, I mean, it is what it is, but to put it into context, I think it's much more important when you're looking at collecting sensitive personal data. So if you have inaccurate information, medical information about individuals, or criminal history, information about individuals, if there's a data breach, of course, that's going to have a much bigger impact, and then a far bigger impact on your organisation, because not only will the ICO look at it more seriously, but you might have claims by individuals for that scenario. But on a more simple level, if you've got the wrong email address to someone, or they've told you to take them off your database and you keep contacting them at their old address or something, that's going to start to get irritating and it might end up in a complaint to the ICO. Storage limitation is about your retention and destruction policies. So I've spoken to a number of clients where they have a whole load of information in archiving. Not only does that start to be expensive over the years, but it does expose you a lot more. I mean, paper documents, I'm not suggesting any of you do that, but, you know, paper documents you don't need, containing personal data you don't need, get rid of it if you can. And I know it's a bit of an onerous task, but it's worth considering. And actually, it's worth mentioning here that 25th of May is not a drop-dead date. You're not going to have the ICO knocking on your door on the 26th of May. It's got to be a continuous process. And so if it's something that you can incorporate into your procedures going forward, then I recommend that you do so. Integrity and confidentiality is more about the security in your systems. So not really within our remit. That's to do with your IT securities. So that's the canter through the GDPR principles. And takes us on to step 3, and I appreciate that some or many of you may already have done theirs, and it seems simple, but just to start with, are you actually processing data? And what does processing mean? Well, it means collecting, recording, storing, disseminating, passing on, making available. And I think one of the things that kind of gets overlooked is just storing is processing data. So, and then to look at whether it's personal data, because in actual fact I've had conversations with clients when they thought they're storing a lot of data, but it turned out it wasn't personal data because you could not identify a living individual from that data.
So that means it falls outside the reg if there's any, the regulations if anyone's not clear on that. Not personal data, not captured by the GDPR.
Yeah, or either data from which you can identify an individual or two bits of data when put together on the same storage on the same piece of paper, wherever it's kept, that you can identify an individual from. And then sensitive personal data is data which might be used to hold against or to discriminate against an individual, really. And we're looking at racial or ethnic origins, sexual preferences, medical background, and then criminal history, which, as I said, isn't really sensitive personal data, but you need to be more careful with. So that's that. You work out in the first instance whether or not you are actually processing personal data, and as Sarah said, that's internal and external. So I think a lot of clients that I've spoken to are focused on the external, but actually the internal is quite important, and for a lot of you, you'll have information about your employees that's more sensitive than you will about external individuals.
What I would just add, if that's all right, Emma, is I think you're more likely to get a disgruntled or an aggrieved employee, either
or ex-employee,
either taking data and breaching it for you, and or asserting that you have breached their personal data and asking for their own data and the data they hold, and you effectively making an access request. So, you know, it is important that any of your clients' data is safe, but don't forget that internally you probably hold far more sensitive data about your employees than you do about your ultimate insurers or customers. And lots of people say, well, we'll do it externally and then we'll think about our employees afterwards. Okay, so there is one strategy that says you should do that, but one needs to be just mindful of where your organisation is and what the real risk is of having disgruntled employees.
And also that's past and prospective employees as well, because you might have information on your database about ex-employees and applicants for positions, so that's to bear in mind.
And clients have always been subject to the DPA, so for those of you who have been compliant with the Data Protection Act thus far, you're probably halfway there for GDPR anyway. But as I say, there haven't been these rules protecting employees' data until now, so this is a whole new genre of kind of policies and procedures you need, or I anticipate you'll need to implement.
So once you've been through all of that and you've worked out your data, then I suggest, again, we have done so already, that you keep a record of the categories of data that you are holding, the categories of personal data you're holding, because what the next stage is to look at the purpose for which you're holding that data and to assign a lawful basis. So, yeah, so when we're looking at the purposes, I came up with a list of examples that might apply here, and that is for the purposes of obtaining an insurance quotation, to administer an insurance policy, for example, to deal with claims, renew business, transfer perhaps business, a book of business, and then the internal point about staff records and employment information, and that might be kept in hard or soft copy. And I think that takes us on to the identification of the lawful grounds. So this is right. So you'll know, I'm sure, that under the GDPR there are a number of lawful grounds that you can rely on. I've already mentioned them. I think the most relevant here, it will depend on whether it's personal data or sensitive personal data, and you may have other examples, but I think for us the most relevant and necessary for the performance of a contract, the legitimate interest lawful basis, which I'll come on to in a bit more detail because it's a slightly more complicated one. Compliance with legal obligation, that found its way in there. That might apply. I think it's less relevant right now. Consent And consent might apply to personal data if you don't have another lawful ground you can rely on, but it will be more relevant in more cases for sensitive personal data where you require explicit consent from the individual whose data you're processing. And then we have legal claims and public interest. And again, I'm sure you all know there's been a bulletin about this, that within our insurance and data protection bill, as it currently stands, making its way through the House of Commons and nearly at the end of that process, there is the lawful basis for sensitive personal data for processing for purposes of insurance. And that comes within the public interest area. So there we have it. If you should all have booklets in front of you, and at Appendix 2 they list the lawful grounds for processing personal data and sensitive personal data, summarised. Or it might be verbatim, I'm not sure. And then I think we're on to the practical examples. So this one I'm going to hand back to Sarah. This is just
to wake you up, make sure you've been paying attention to Helena. And also to kind of give you a bit of confidence, because I think lots of people think they don't know, but the reality is they do know what data they're holding within their organisation. And so we wondered if you would mind, or please, just turning around to the person to your right or your left, and just having 2 or 3 minutes to kind of talk through what the lawful grounds are for holding data in the scenarios that we set out here on this slide, and then we'll feed that back and maybe discuss that just for 5 minutes or so, just to make it a little bit more practical.
Can I just add it's not necessarily what the lawful grounds are as well, it's what they might be, because actually as an organisation, if you decide on a lawful basis and you record it and you justify it,
it can be whatever you want.
It will be almost. But yeah, you can choose, yeah.
So what we thought we would do is we just hand over to you guys for a few minutes, and then perhaps take some feedback for a couple of minutes. Everyone's looking shocked and stunned and very disappointed. And then you can feedback and we can perhaps have some discussions about that. So I hope you found that interactive session useful, or at least it got people to kind of think about it. Actually, this exercise probably isn't quite as difficult as one might think when one reads a regulation. Actually, because when you look at it from a practical point of view, you know why you're holding the data. You just have to look through the list and see which one's most difficult. But it is a case of separating each box of data and different parts of your business, because there might be different reasons why you're holding the data, and that's the key thing to getting this exercise right. So we're just going to come off from legitimate interest, because I think this is one of the things we've kind of been edging around and talking around, so it's probably useful for everyone now.
And it's to your point actually about legitimate interest, and if you are going to be relying on legitimate interest, you need to carry out a legitimate interest assessment, and that means you need to identify what your legitimate interest is. So I am going to use marketing as an example again. As an organisation, I think you can say that it's in the legitimate interest of the business to market to individuals. And the next stage is to, and actually, sorry, go back a step, the GDPR envisages that as well, that would be a legitimate interest of a business. And we're assuming that you're marketing directly to individuals here, so you're using personal data to market to them. The next stage is to see whether it's necessary for your business, and that will involve looking at whether there's other ways of reaching those individuals, other ways of getting that information to the individuals. And then you move on to the balancing test, which is what we were discussing earlier. So that will be looking at whether it's in the reasonable expectations of the individual to receive that marketing. So that might be the case, for example, if an individual has taken out medical insurance and you're marketing a dental product to them, that would be reasonable to expect that they would expect to receive such marketing materials. And then the impact on their privacy. So always focusing on whether or not they've asked not to be marketed to. And here, if you're marketing, and this is a whole other topic, but if you're marketing by electronic methods, so by email, and in most cases that will be so, then you need to take into account the privacy and electronic communication rules as well. And that requires consent for marketing if a rather convoluted exception doesn't apply. I'm not going to go into any more detail, just say to flag that you do need to be aware of PECA, the electronic communications regulations, and they're being updated. So they're due to be updated in 2019.
And by the way,
just to complicate matters.
everyone should already be compliant with those, which I'm sure you all are, so we don't need to worry about that, right?
So that's a good point. They exist already. So if you're sending marketing out by electronic means, then you should be obtaining consent within the privacy and electronic communication regulations already. So that's slightly quicker through legitimate interest, because we're running out of time a little bit. Consent. We wanted to make the point actually that consent seems to be the first lawful grounds that lots of organisations talk about, but I would urge you to consider all the other lawful grounds before you look at consent. And I'm talking about personal data here only because sensitive personal data, it may well be that explicit consent is your only option. But if you are relying on consent, then there are various boxes you need to tick, and that is that consent is freely given, it's unambiguous, it's not buried in T's and C's, etc., and they're all listed here.
And I would emphasise the fact that the reason why we're not recommending that you rely on consent as your first port of call is because you can't control consent. You can control the other two, legitimate interest and performance of the data, but consent, you're relying on that person to come back and expressly consent to you holding that data. If they fail to give you that consent, then technically you can't hold that data. So, it is a difficult one, and also from an operational perspective, if you went out to each and every insured and asked them to consent, it's going to go wrong. It's not going to be without flaws. So, from a practical point of view, if you're relying on consent across the whole of your business, you may as well employ a whole team of people to do it, would be my view.
The other thing about consent is if individuals given consent, they can withdraw consent. But if you're relying on legitimate interests, they can object to it, but it's not the same kind of mechanism when they can just take the consent back.
So use consent with caution, I think. Consent with caution. If you can do another means, then probably rely on a different ground.
So that skips on quite neatly, I think, to step 5, which is your privacy statements, and links in with the transparency principle. So you need to be telling individuals what you are doing with their data and the lawful basis upon which you are relying. And that needs to be worked into your privacy statements. Within the privacy statements, you need to tell the individuals who you are, what you're doing with their data, the lawful basis, and you need to set out their rights. And we'll come on to those rights in a short while. But if you're asking for consent, then you'll need to be documenting consent separately. And I don't know how many of you are aware, there's been guidance issued as to how consent's obtained in the insurance industry by the LMA, EBA, LIBA, the IUA, and it's really very helpful. It sets up the layered approach. It sets out what you should be telling individuals in your privacy notice about how they find out who's the controller of the data. So if you haven't seen that already, I highly recommend it. It's very, very simple, very helpful. It also gives some more guidance about how you go about telling individuals where this information is. So it might be that if you've got a direct ToBA, for example, you simply provide a link to a privacy statement on your website, or if in another contract, in the policy document, in a proposal form, then you signpost your privacy statement to the individual.
I was actually asked the question just in the last break about three insurers, 3 different privacy statements. None of them have necessarily all transpired, so we don't know what they're saying. So in that scenario, it's very difficult. But one way around it, as Helen has just suggested, is in your policy documents, signpost their privacy statement. So as long as they tell you the signpost, then you can do your back-end documents that point them in the right direction for the appropriate privacy statement rather than waiting for the words. It also means every time they amend their privacy statement, you don't have to update your policy wordings, because if they change them slightly, then each and every time you need to make sure it's accurate. So it's much better to use the signposting model rather than putting the full verbatim.
And that actually goes to the question you asked earlier about whether you need to list all the purposes. If you've got your privacy statement online, if another purpose comes up, then you can assess it, change it, update it. And you should be doing that anyway, as and when your process and activities change, you should be carrying out a new assessment.
You might have a new class of business, a new TPA, and all kinds of different reasons. So that's the best way to use signposting
So the next step is, I would say, to review your internal policies and procedures. And this really, for me, wraps up all of the other principles we haven't necessarily picked up and everything else we've spoken about. So the policies we would expect to see is your data protection policy, which will be your internal guidance for staff about what to do in the event that there is a request by an individual enforcing their rights, a subject access request, which have changed slightly under the GDPR. They existed already, but now the individuals don't need to pay for them. There's a certain period of time in which you need to respond. It's thought that because there's no longer, albeit a small fee, that there will be much more of these requests. So again, that might be over eggs. We might not really see any.
And I suspect employees historically haven't asked for it. Now they could well if they were let go of in rather unfavourable circumstances. But the most important thing with all these policies and procedures is, and Helen has been saying this to all our clients, is the most important thing is that you actually do what you say what you can do and do what you say. So this kind of brings you back to don't overcomplicate things. Try and keep things proportionate, keep them within the remits of the size of your organisation and the sophistication of your organisation, and most importantly, train your staff. If they don't know what to do, then they are the ones that are going to cause you to firstly breach the regulation, and secondly not be able to deal with the quite tight timeline should a breach occur within the regulation. The most important thing is developing a culture and a framework within your organisation where people realise that a data breach isn't necessarily a bad thing. It's one of those things that happen, and actually the worst thing you can do is hide it. The best thing to do is actually deal with it, because then the fine that is levied against you is going to be reasonable and proportionate if a fine is levied.
Or even the sanction, it doesn't necessarily need to be a fine. It's just what the ICO does in terms of dealing with a breach. Yeah, I agree. The data retention policy we've really discussed in some depth, but it takes on to breach as well. What I'm thinking of in terms of your internal procedures is that where you have a member of staff, an individual could call up, speak to a member of staff who just doesn't know what to do, but tries to be a good member of staff and tries to deal with it. So these procedures need to be there. And staff need to know where they are and what they do. So you should be providing training if you're not already, and your staff need to know where these policies are.
And this all links back to your responsible board member. Because if your staff don't know, they need to get it to the responsible board member, who one hopes will know.
Yeah, or your DPO if you have one. and the same applies to breach, of course. There needs to be some kind of breach response policy. So all staff need to know who to go to in the event of a breach. And there are some handy templates out there already that have been issued in respect of breach responses and how you report those to the ICO. We recently issued an update which provided a link to those templates. So if you would like some of those, can you please let us have your card afterwards and we can ping that over to you if it's useful. That should be appended to your breach response policy, of course, so that people know what information is required, what your staff know that. I think we're on to individual rights now, but I'm going to skirt over that because actually we really don't have much time, and you can all read what, so that's what it says. So that's a little bit more, a little bit less practical, but these should be in your procedures as well. Your internal data protection procedures should list what the individual rights are and what that means. And the reason I want to skirt over that is because I didn't want to miss out on third-party contracts, because I think they're particularly relevant in this scenario. Again, guidance and model wording has been issued on some third-party contracts. So binding authorities, if you haven't seen it already, have been updated to include the data protection clause, GDPR compliant, as have intermediary ToBAs, wholesale ToBAs, and third-party suppliers, the TPA agreements, and also consortium agreements. So there's been a good circular with updated clauses. And what is important here is ascertaining who's the controller and who's the processor. So the industry guidance is that where you have an intermediary ToBA, I'm just going to call them intermediary ToBAs for these purposes, then both parties are controllers when they are processing the data that they're processing. But if you have a scenario where you've got a controller and a processor relationship, there's ICO guidance that lists mandatory clauses that need to be included in those contracts. And that's a whole checklist pages, 2 pages, 3 pages of clauses that need to be included in contracts. My view is that they don't have a place in ToBAs because that's not what ToBAs are meant to be. But you might have third-party supplier agreements, maybe your, I don't know, TPA agreements, where it is appropriate to have more full obligations, and that's because if you are acting as the controller and another organisation is acting as a processor, you are ultimately responsible for a great deal of the obligations under the GDPR, and you want to be able to ensure that the parties with which you're contracting have those obligations in their contracts as well. And that's to protect you as the controller. If you're the processor and another organisation is the controller, I would expect to be seeing those types of clauses and obligations put upon you. And I think that does lead us on to our next exercise. If we have time,
Peter, for one more exercise?
I suggest, can we just run through it?
Okay.
So
what we were hoping to be able to do was run you through a bit of an assessment on ToBAs, because we've had a whole ream of questions about ToBAs. ToBAs over the time have ceased to be 20-page documents and now are kind of a nice candid 4 or 5 pages of pretty clear instruction and arrangements between the parties. If one looks at the ICO guidance, one could have a ToBA document that's 4 pages long and a data protection provision which is spans the 20 pages, which in our view is neither right, proper or appropriate, and actually probably would lead you to greater exposures than protections. So we were hoping to run our second practical workshop on ToBAs, but what I'd like to do is maybe ask you to shout out some of the responses, because one of the things that we've been emphasising to our clients when they look at ToBAs, and let's take the wholesale ToBA as an example, is they need to look at the factual circumstances, i.e. what's the client type? Are they an SME? Are they a reinsured? Are they kind of a cedant? Because are they a large multinational, right? So that's the first thing one needs to consider. What class of business is your ToBA covering? Is it retail business or is it SMEs, commercial type business? And when we say retail, I'm talking about, is it travel and or is it household? Because they're the ones where there's potential for personal sensitive data. And what people are also finding quite difficult, because they use, oh, we're data controller, we're data processor. Obviously the insurer is the data controller. Well, the answer is not in every scenario. So once again, you have to look at the individual facts surrounding it. So you need to just see what the person does with the data at that point in time, i.e. who collects the data, who passes the data, does one party pass the data to the other party and tell them what to do with it? And if they tell them what to do with it, why are they telling them to do this? And actually, you'll probably find in most of your ToBA arrangements that in various stages in your arrangement, your business arrangement, you assume the role of data processor and data controller, depending on what your hat you're wearing at that point in the data chain. And so you need to look at the factual scenarios and agree, and don't just don't accept from your insurer as an MGA business that you are the processor. I would always argue that you are the controller. It's your business, you're collecting it, and actually you control with whom it's placed. And in fact, you often instruct TPA. So why aren't you the controller? Because you're instructing that TPA to do something with that data. You too are the processor for the insurer, because you're preparing that information for them, you're storing it for them, and you're sharing it with them. So just in that scenario, you assume both roles just in that kind of scenario. So much the same as when you're looking at your lawful grounds, you need to look at what point and what you're doing with your data to ascertain whether you're controller or processor. And there are some handy, or some are less handy, clauses that are floating around the market, but there is one where that anticipates a scenario where you are both controller and processor at various points. And that probably for most of you will be what I would recommend you insert within your ToBA. So apologies, we haven't had time to go through that and give you kind of a more structured guidance, but ToBAs are and will continue, I think, to be an area of debate and discourse. But once again, the LMA have issued some useful guidance, so get hold of it and have a look at it would be my advice. Is there anything you want to add on that quickly?
No, I think that's it on third-party contracts. What we've achieved today in a a quick canter through it. Do we have any more questions? Do we have time for?
Yeah, we've got time
questions,
for questions.
Peter?
If people have video.
We didn't get
Guys
to.
at the front, you had questions. Okay, ladies and gentlemen, let's call this session to a close. Will you please join me in thanking Sarah and Helen?